Ripple has just achieved another significant victory in the SEC case. What exactly occurred? And will it be Ripple's final victory over the SEC? To discover out, watch the video until the conclusion. But first, at the end of the month, we'll give away $25 to one fortunate subscriber to help them get started with XRP. All you have to do is click the like button on the video, subscribe, and leave a remark in the comments area with your opinion on XRP. Greetings, XRP Army. Ripple's situation was not looking good. Judge Sarah Netburn denied John Deegan's motion and ordered the Securities and Exchange Commission to extend the deadline for expert discovery until January 14, 2022. While the court recognizes that both parties have expended significant resources to prosecute this case, given the pending motions to dismiss and strike, and the previous adjournment of any deadline to file a motion for summary judgment, the additional time sought by the SEC will have no effect on the schedule for resolving this case. Rather, the additional time requested by the SEC will allow both parties to complete outstanding fact discovery and adequately prepare for expert depositions, Judge Netburn concluded. However, things took a turn for the worse. The SEC is specifically obligated to explain how the Howey test applies to XRP, the current status of Ether and Bitcoin, and whether or not XRP can be purchased as investment contracts, among other things. In a surprising move, District Judge Sarah Netburn opted to hear two remaining motions in the SEC v. Ripple litigation the same week she granted an extension of the expert discovery deadline to January 14, in a decision that surprised many people. The SEC is compelled to provide clear responses to individual defendants' interrogatories after responding to their applications to compel. The order also indicates that the SEC protective order, which relieves it of the burden of responding to 29,947 individual admission petitions, must be followed. Because the sought-after discovery overlaps in some ways, these applications are resolved together. Finally, Judge Netburn determined that both motions are granted in part and refused in part. The judge also ordered the SEC to answer to around 30,000 requests for admission, which included, among other things, requests to establish the legitimacy or authenticity of a document, requests related to the fair notice argument, and requests related to Ripple's extraterritorial defense. Defendants' protests that the volume of requests is appropriate and will reduce the topics for trial were discarded as theater. Despite the defendants' protests that this volume of requests is fair, and because this act will narrow the issues for trial, it is difficult to see this stunt as anything other than theater. According to Judge Netburn, who addressed Ripple's interrogatories on the SEC position on cryptocurrency investment contracts, the SEC legal theory is not an excuse for declining to respond to the defendant's factual inquiries. It cannot be used as the basis for answering a question that was not posed in the initial inquiry. It has also been ordered that the Securities and Exchange Commission, SEC, answer to the question of whether Bitcoin and or Ether are securities under Section 2 of the 1933 Securities Exchange Act, despite the fact that the agency has previously stated that they are not. It has previously indicated that it does not normally determine whether or not a specific financial instrument is a security under the 1933 Securities and Exchange Act. Do you believe Ripple will win the case? Please let us know in the comments section below. To the degree that the parties differ on the application of Howey and its progeny, the parties' disagreement over the application of Howey and its progeny do not render Ripple's interrogatory improper. The Securities and Exchange Commission also requires responses. SEC. Judge Netburn, on the other hand, denied Chris Larson's motion to determine whether the XRP ledger was not completely functional prior to the start of the ongoing securities offering described in the complaint and when it became functional, based on the SEC interpretation of the time period, and when it did become functional. Because the court determined that the interrogatory was unduly vague, it was ordered that the parties meet and discuss in good faith to further define the words. There is a general lack of clarity in the digital asset industry. That is something practically everyone agrees on. While the SEC v. Ripple case will not immediately benefit the industry, it will set a precedent for future enforcement proceedings and litigation against the SEC launched by other companies. Also, Garlinghouse, the CEO of Ripple, has been vocal about cryptocurrency rules and the health of the cryptocurrency industry, and it appears that he holds a grudge towards the Financial Industry Regulatory Authority, FINRA, for its treatment of Ethereum. Speaking at the DC FinTech Week virtual conference on Thursday, Ripple's CEO indicated that Ethereum has received formal approval, allowing it to outperform his company's XRP cryptocurrency in terms of market value. The U.S. Securities and Exchange Commission has been investigating Ripple over allegations that its cryptocurrency, Ripple, XRP, is an unregistered securities, which the company vigorously denies. Ripple filed a Freedom of Information Act request with the Securities and Exchange Commission in January. The company was curious as to why the SEC did not classify Ethereum as a financial security, in order to depose a former SEC officer who earlier stated that Ethereum was not a currency. The security was given in July, 6 months after the company first requested it. Garlinghouse is unequivocally of the opinion that his company has been treated unfairly, and it is probable that Ethereum's subsequent success is owed, at least in part, to the SEC's more lenient regulation of cryptocurrencies, in addition to claiming that it has an impact on the market. He went on to state that XRP was the second most valuable digital asset during the last few years. As it became clear that the SEC had given ETH a pass, ETH definitely skyrocketed, and that clarity has helped. Garlinghouse, for example, referenced recent proceedings against his own company and Coinbase as proof of the Securities and Exchange Commission's SEC's severe attitude against Bitcoin. Ripple's legal battle with the Securities and Exchange Commission spurred him to say that while the SEC professes to safeguard customers, it in fact does the opposite. You have approximately 50,000 XRP holders in the United States attempting to sue the SEC for protecting them. Do you concur with him? If so, be sure to like this video. Furthermore, lawmakers criticize the SEC's dismissive attitude towards cryptocurrencies, particularly XRP. Tom Emmer, a member of the Minnesota House of Representatives, wrote a letter to the editor. He is also the co-chair of a group of legislators interested in blockchain technology. Voiced concern that Gensler was abusing his power by attempting to broaden the SEC involvement in regulating cryptocurrencies like XRP. In reaction to Democrat-led efforts to improve control of the $2 trillion cryptocurrency industry, Bitcoin fans are organizing a larger movement to oppose such measures. Emmer's involvement is a part of that movement. If you agree with Emmer, please leave a comment with the phrase XRP Army. Gensler told Congress on Tuesday that he wanted cryptocurrency platforms to be registered with the Securities and Exchange Commission, saying, "Right now, investors don't get the benefit of the basic agreement that we safeguard individuals against deception and manipulation. Someone is going to get hurt." I strongly disagree with Gensler when he suggests that practically all of these crypto goods are securities. Emmer informed the audience, "I believe that the great majority of cryptocurrencies or related items are in fact money or commodities. There is no involvement from the SEC." He is also opposed to the SEC anti-crypto policies in general, and especially to the fact that they have greatly hurt Ripple and XRP. What are your thoughts on the newest Ripple vs SEC news? Do you believe these will result in Ripple's victory? Is that correct? Please let us know in the comments. If you want to learn more about XRP, we have 2 videos waiting for you at the bottom of the page. Please subscribe and give us a thumbs up. Thank you very much for taking the time to watch. Look forwards to seeing you in the future video. Please keep in mind that cryptocurrency prices change rapidly, so by the time you see this video, it may have changed to a completely different value. The information in this video does not represent investment advice, financial advice, trading advice, or any other type of advice, and you should not take any of it as such. This video's information is intended solely for educational purposes and should not be construed as financial advice. Execute actions. Before making any investment decisions, conduct your due diligence and consult with your financial advisor.